Hi, my name is Robert Shelley with Chelle Law, and my law firm assists physicians with employment contract issues. Today I'm going to discuss what is mediation in a physician employment contract. So, in nearly every physician contract, there's going to be a couple things about here's what happens if there is a dispute. So, uh, everyone goes into a contract hoping that it's the greatest relationship of all time. Unfortunately, it doesn't always happen. And so if there is some kind of dispute, or you think that, one party thinks the other is in breach of contract, and you just can't meet in the middle, usually the contract will state a couple of things. So one, it will state what law is used. So it should be the law of the state that you're in. I've seen a couple like larger corporate owned physician groups where maybe they have physicians in dozens of states and they're based in Florida or something. The contract will state, although the contract's taking place in Texas, Florida law will hold. I mean, no one should agree to that. The laws of the state where you're working should be the venue for any kind of dispute. It may even specifically state, like for instance, here in Arizona, Maricopa County is, basically the Phoenix area and surrounding cities. And so it may state in the contract that any lawsuit that's brought has to be filed in the Superior Court with Maricopa County. So that's not unreasonable as well. It can state exactly where, if there is some kind of issue, that's where it will be filed. Other contracts will state there has to be some kind of dispute resolution process. So instead of someone just going straight to court and filing a lawsuit, they'll state there has to be some kind of maybe accelerated dispute resolution. And so in the legal field, dispute resolution generally is two things, either mediation or arbitration. And so mediation is non-binding arbitration. So what that means is usually a lawyer, maybe a retired judge, will kind of attempt to reach some kind of compromise between both parties. However, if both parties are not happy with the outcome or not willing to compromise, nothing binding results from it. So usually in a mediation, what will happen is both parties will usually split the cost of the mediator. And as I said before, it's a lawyer, a retired judge. And then, usually they'll keep them in separate rooms. And then the mediator will then, go to one side and say, what's your position on this? Then they'll go to the next room and say, all right, what's your position? And then they'll kind of go back and forth saying, well, maybe you're being unreasonable here, or maybe you might want to think about this. And so they're just trying to get both parties to meet in the middle and, squash any beef that they have. But if it is an unsuccessful mediation, then it can go one of two ways. It could either go to arbitration, which is binding mediation essentially. And so in arbitration, same process. An attorney, retired judge will hear both sides of a case. And in an arbitration, they'll render a binding decision. So both parties are bound by whatever the decision was. And it's outside of the court system. I find almost every hospital network employs an arbitration agreement within the employment agreement. So it will state if there are any disputes arising from this agreement, sometimes, accepting the restrictive covenants. So sometimes the non-compete, non-solicit will have to go through the court system. It won't be part of the arbitration agreement. But anyway, it'll say if there is some kind of dispute, both parties must go to arbitration. And then it will state what kind of arbitration. So it could be JAMS, it could be AHLA, the American Health Lawyers Association. It could be the arbitration system of whatever county they're in. And so how arbitration normally works is both parties will come to some kind of agreement on a neutral arbitrator. They'll provide a statement to the arbitrator in advance, maybe submit documents if they're necessary. and then the arbitrator will come in, and then the same process happens. They'll meet with both sides, and then they will then render a decision. Generally, it's a brief written decision of this is what's going to happen. Now, if there isn't mediation or arbitration, then it just simply goes to litigation, meaning if the parties can't reach an agreement, either party is free to sue them in whatever venue is specified in the contract. There is no downside to mediation. It's not binding. It's generally, because it's considered settlement, whatever is stated within those settlement talks is considered confidential and then can't be used against either party if it does accelerate into arbitration or litigation. I find it's a pretty meaningful process to kind of flesh out what the actual issues are. Like what really is the bottom line problem? And then having somebody who's skilled in mediating and trying to get both parties to compromise is a valuable process. Now, dealing with doctors every day, I understand there are some hard feelings at times. And so some people say, absolutely not. I don't want to mediate. I'm just going to straight to bringing out the big guns and going right into litigation. And that's their prerogative. That's fine. But I do think the mediation process can be fair and helpful in many ways. So that's kind of what mediation is in a physician employment agreement. If you have any questions, you can always contact us at the phone number listed below in the description, or you can always reach us through our website, chellelaw.com. That's CHELLE law.com. I appreciate you watching the video. Thanks.